Rule 130, 3. Admission and confession. Section 27, admission of a party. The act, declaration, or omission of a party as to a relevant fact may be given in evidence against him or her. Section 28, offer of compromise not admissible. In civil cases, an offer of compromise is not an admission of any guilt and is not admissible in evidence against the offeror. Neither is evidence of conduct nor statements made in compromise negotiations admissible, except evidence otherwise discoverable or offered for another purpose, such as proving bias or prejudice of a witness, negativing a contention of undue delay, or providing an effort to obstruct a criminal investigation or prosecution. In criminal cases, except those involving quasi-offenses or criminal negligence or those allowed by law to be compromised, an offer of compromise by the accused may be received in evidence as an implied admission of guilt. A plea of guilty later withdrawn or an accepted offer of a plea of guilty to a lesser offense is not admissible in evidence against the accused who made the plea or offer. Neither is any statement made in the course of plea bargaining with the prosecution which does not result in a plea of guilty or which result in a plea of guilty later withdrawn admissible. An offer to pay or the payment of medical, hospital, or other expenses occasioned by an injury is not admissible in evidence as proof of civil or criminal liability for the injury. Section 29. Admission by third party. The rights of a party cannot be prejudiced by an act, declaration, or omission of another, except as hereinafter provided. Section 30. Admission by a co-partner or agent. The act or declaration of a party or agent authorized by the party to make a statement concerning the subject or within the scope of his or her authority and during the existence of the partnership or agency may be given in evidence against such party after the partnership or agency is shown by evidence other than such act or declaration. The same rule applies to the act or declaration of a joint owner, joint debtor, or other person jointly interested with the party. Section 31. Admission by conspirator. The act or declaration of a conspirator in furtherance of the conspiracy and during its existence may be given in evidence against the conspirator after the conspiracy is shown by evidence other than such act of declaration. Section 20 Section 32. Admission by parties. Admission by privies. Where one derives title to property from another, the latter's act, declaration, or omission in relation to the property is evidence against the former if done while the latter was holding the title. Section 33. Admission by silence. An act of an act or declaration made in the presence and within the hearing or observation of a party who does or says nothing when the act or declaration is such as naturally to call for action or comment if not true, and when proper and possible for him or her to do so, may be given in evidence against him or her. Section 34. Confession. The declaration of the accused acknowledging his or her guilt of the offense charged or of any offense necessarily included therein may be given in evidence against him or her. Number 4. Previous conduct as evidence. Section 35. Similar acts as evidence. Evidence that one did or did not do a certain thing at one time is not admissible to prove that he or she did or did not do the same or a similar thing or at another time, but it may be received to prove a specific intent or knowledge, identity, plan, system, habit, custom or usage, and the like. Section 36. Unaccepted offer. An offer in writing to pay a particular sum of money or to deliver a written instrument or a specific personal property is, if rejected without valid cause, equivalent to the actual production and tender of the money, instrument, or property. Number 5, hearsay. Section 37, hearsay. Hearsay is a statement other than one made by the declarant while testifying at a trial or hearing, offered to prove the truth of the facts asserted therein. A statement is 1. An oral or written assertion, or 2. A non-verbal conduct of a person, if it is intended by him or her as an assertion. Hearsay evidence is inadmissible except as otherwise provided in these rules. A statement is not hearsay if the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement, and the statement is A. Inconsistent with the declarant's testimony, and was given under oath subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. B. Consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant or recent publication or improper influence or motive. Or C. One of identification of a person made after perceiving him or her. 6. Exemptions to the hearsay rule. Section 38. Dying declaration. The declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his or her death is the subject of inquiry as evidence of the cause and surrounding circumstances of such death. Section 39. Statement of decedent or person of unsound mind. In an action against an executor or administrator or other representative of a deceased person or against a person of unsound mind, upon a claim or demand against the estate of such deceased person or against such person of unsound mind, where a party or assigner of a party or a person in whose behalf a case is prosecuted testified on a matter of fact occurring before the death of the deceased person or before the person became of unsound mind. Any statement of the deceased or the person of unsound mind may be received in evidence if the statement was made upon the personal knowledge of the deceased or the person of unsound mind at a time when the matter had been recently perceived by him or her and while his or her recollection was clear. Such a statement, however, is inadmissible if made under circumstances indicating its lack of trustworthiness. Section 40. Declarations against interest. The declaration made by a person deceased or unable to testify against the interests of the declarant, if the fact asserted in the declaration was at the time it was made so far contrary to the declarant's own interest that a reasonable person in his or her position would not have made the declaration unless he or she believed it to be true, may be received in evidence against himself or herself or his or her successors in interest and against third persons. A statement tending to expose the declarant to criminal liability and offer to exculpate the accused is not admissible unless corroborating circumstances clearly indicate the trustworthiness of the statement. Section 41. Act or declaration about pedigree. The act or declaration of a person deceased or unable to testify in respect to the pedigree of another person related to him or her by birth, adoption, or marriage, or in the absence thereof, with whose family he or she was so intimately associated as to be likely to have accurate information concerning his or her pedigree, may be received in evidence where it occurred before the controversy, and the relationship between the two persons is shown by evidence other than such act or declaration. The word pedigree includes relationship, family genealogy, birth, marriage, death, the dates when and the places where these facts occurred, and the names of the relatives. It embraces also facts and family history intimately connected with pedigree. Section 42. Family reputation or tradition regarding pedigree. The reputation or tradition existing in a family previous to the controversy in respect to the pedigree of any one of its members may be received in evidence if the witness testifying thereon be also a member of the family, either by consanguinity, affinity, or adoption. Entries in family Bibles or other family books or charts, engraving on rings, family portraits, and the like may be received as evidence of pedigree. Section 43. Common reputation. Common reputation existing previous to the controversy as to boundaries of or customs affecting lands in the community, and reputation as to events of general history important to the community or respecting marriage or moral character may be given in evidence. Monuments and inscriptions in public places may be received as evidence of common reputation. Section 44, part of the res gestae. Statements made by a person while a startling occurrence is taking place or immediately prior to subsequent thereto under the stress of excitement caused by the occurrence with respect to the circumstances thereof may be given in evidence as part of the res gestae. So also, statements accompanying an unequivocal act material to the issue and giving it a legal significance may be received as part of the res gestae. Section 45. Records of regularly conducted business activity. A memorandum, report, record or data compilation of acts, events, conditions, opinions, or diagnoses made by writing, typing, electronic, optical, or other similar means at or near the time or from transmission or supplies of information by a person with knowledge thereof and kept in the regular course or conduct of a business activity. And such was the regular practice to make the memorandum, report, record, or data compilation by electronic, optical, or similar means, all of which are shown by the testimony of the custodian or other qualified witnesses, is exempted from the rule on hearsay evidence. Section 46. Entries in official records. Entries in official records made in the performance of his or her duty by a public officer of the Philippines or by a person in the performance of a duty especially enjoined by law are prima facie evidence of the facts therein stated. Section 47. Commercial lists and the like. Evidence of statements of matters of interest to person engaged in an occupation contained in a list, register, periodical, or other published compilation is admissible as tending to prove the truth of any relevant matter, so stated if that compilation is published for use by person engaged in that occupation and is generally used and relied upon by them therein. Section 48. Learned entries. A published treatise, periodical, or pamphlet on a subject of history, law, science, or art is admissible as tending to prove the truth of a matter stated therein if the court takes judicial notice or a witness expert in the subject testify that the writer of the statement in the treatise, periodical, or pamphlet is recognized in his or her profession or calling as expert in the subject. Article 49. Testimony or deposition at a farmer proceeding. The testimony or deposition of a witness deceased or out of the Philippines or who cannot with the due diligence be found therein or is unavailable or otherwise unavailable to testify, given in a former case or proceeding, judicial or administrative, involving the same parties and subject matter, may be given in evidence against the adverse party who had the opportunity to cross-examine him or her. Section 50. Residual exemption. A statement not specifically covered by any of the foregoing exemptions, having equivalent circumstantial guarantees of trustworthiness, is admissible if the court determines that a. the statement is offered as evidence of immaterial fact, b. the statement is more probative on the point for which it is offered that any other evidence which is the proponent can procure through reasonable efforts, and c. the general purposes of these rules and the interests of justice will be best served by admission of the statement into evidence. However, a statement may not be admitted under the exemption unless the proponent makes known to the adverse party sufficiently in advance of the hearing or by the pretrial stage in the case of a trial or the main case to provide the adverse party with a fair opportunity to meet it, the proponent intention to offer the statement and the particular of it, including the name and address of the declarant.